Ready? I see Mr. Moore.
Yes, Your Honor.
All right. Counterpart here. Mr. Haas. I think everyone signed in. Oh, there you are. Good morning, sir.
Good morning, Your Honor.
Haas, would you like to reserve any time for rebuttal?
Yes, Your Honor, I'd like to reserve 5 minutes, please.
All right, sir, you may proceed.
May it please the court, I am Lee Hawes, counsel for appellant Cynthia Kistner. I don't want to bore you. I'll just focus on the salient facts and the law. Ms. Kistner, in August of 2014, more than 10 years ago, sued the defendants on a 2-count complaint. The first count was to invalidate a transfer of property by quitclaim deed in a condominium.
I got a question about the standard of review.
Standard of review is de novo.
Why? What interpretation of what legal document, contract, or statute is required?
The issue is pure interpretation of law. This case.
What law do we have to interpret to determine whether the sanctions motion was properly or improperly denied?
The 57105 and the standard of shall. I mean, under the Suarez
So
case,
so that would mean every time that a 57105 motion was adjudicated, because it's based on a statute, it's de novo.
well, all I can do is cite to this court.
Well, you gotta do more than
Judge
that, 'cause I'm
Valenti
asking you
was
the
a part
question
of.
about what I read the cases you cited.
All right.
Why is under this case a de novo review as opposed to a abuse of discretion?
Because for the very same reason that the Suarez court determined that this was de novo review rather than
No,
abuse
but
of discretion.
well, let me ask you that. Let me go to that, because on the Suarez, did they actually say it was de novo, or they just cite, they just cite the standard because Mr. Suarez and National Packaging failure to plead entitlement was dispositive. We addressed the denial of fees on that basis alone. Failure to plead entitlement is dispositive. We addressed the denial of fees on that fee alone. So it's to know.
Yeah, if I may, Your Honor, the opinion at page 208 says this court, and then it quotes, generally reviews an order denying a motion for attorney's fees and costs under section 57.105 subparagraph 1 for an abuse of discretion. But if the trial court's determination is based on a legal conclusion, such as the interpretation of a statute or contractual provision, a de novo standard applies, citing Schur versus Silverio and Hall, which in turn cites others.
So I was asking you, what provision do we need to interpret?
Well, the point is, Your Honor, first of all, the underlying fee entitlement was 718.303 for me. The issue is that you have.
Is there some sort of interpretive problem with that? Like, in other words, that's based on prevailing party, right?
It's prevailing party under the condominium statute. Right.
So that statute requires interpretation to get to the conclusion.
Well, the answer is the judge gave no explanation for his reasoning as to why he was denying the 57105 fees, despite the citation to Suarez and my recitation of the facts, comparing the facts in Suarez to the facts of this case. And he just denied the motion without any factual explanation. So when you have no factual explanation for the basis for a ruling, when you're presented with a controlling decision of the second district, that's either a per se abuse of discretion, or in this case, because it's clearly based on a legal conclusion, because there's no factual basis offered for his decision. What else can it be?
So the opposing party, of course, is going to try to distinguish Suarez, and one of the things they've asserted is that in this case there was a motion to conform the pleadings to the facts. And why doesn't that bring it out of the ambit of Suarez? in order, in other words, they had a theory that wasn't expressed in Suarez.
Right, and I addressed that in both my initial and reply brief. That's like saying, well, if I tell one lie, I'm captured under Suarez, but if I tell two lies, I can get away under Suarez.
I mean, it says
Because-
what's the basis for denying the motion to conform the pleadings to the evidence?
Because if you've read the transcript of the hearing, Mr. Moore admitted, first of all, two things. Number one, there was no evidence to conform the pleadings to, because remember, he was saying, I want the pleadings to conform to the evidence as to an award of attorney's fees on count 2, except count 2 was never tried. Count 2 is never thoroughly litigated, so there's nothing to conform to.
Could
I'm trying to finish answering your
procedural
question.
facts? Well,
I wasn't
okay.
done. If I can finish answering your question, sir. The second part to the answer is in the transcript, and I pinpointed the actual page of the citation where Mr. Moore admitted that there was
I read that.
no
I
evidence.
read that. I read your
Okay.
brief.
Okay.
So I was about to address that. And what I was about to address is that, yeah, he admitted there's no facts, and I was going to make a hypothetical theory. You don't have to, listen to it if you don't want to, but I'm going to make it anyway. And that is, are procedural facts to which a pleading can be conformed. In other words, the procedural fact is, well, it was dismissed. It was involuntarily dismissed.
But that procedural fact doesn't do anything for him because you still have Stockman v. Downs, Caulfield versus Cantil, I believe, the Lopez. You have all of these other cases that say you have to have a pleading predicate to seek fees. If you don't have that, then your only alternative is what he did, which was to make it up out of whole
Wait a
cloth.
minute. Well, can I ask you a question about that? Are you saying he doesn't have a legal predicate for fees? I mean, in other words, I thought your argument was premised on merely the failure to plead, not whether there was legal entitlement. In other words, had he pled, would there have been entitlement to fees?
I'm not sure that he would have.
Why?
Because again, you've got the whole prevailing on the substantial issues litigated, because again, that
Well, was this count that was dismissed, was it based on the statute?
No. The count that was dismissed, the count that was dismissed was a specific performance claim. And it only would become active, so to speak, once the court ruled on the invalidity of the original transfer. Because what had to happen was, again, there's a declaration of condominium that has a restriction that says you cannot sell your condominium without giving notice to the association of the owners. And the purpose of that is that then triggers in the association and the other unit owners a right to exercise a right of first refusal to exercise an option to purchase on the same terms as the proposed transferee. So that's why we had a 2-count complaint. Count 1 was, again, to invalidate the deed for failure to comply with the process that was set forth in the declaration. And then, assuming the court invalidated the deed for failure to comply with that provision, well, then the property would get back into the Lowrys as the proper owners. And then we would then say, well, we want to specifically enforce, so to speak, this contract right to buy the property. And so we never got to that point because, again, we didn't get to the point of a judgment on our entitlement to have the deed declared invalid until after we had already dismissed the specific performance claim.
Does the specific performance, would it have fallen within the ambit of 718.303C? Well, I guess it's not C, but it's that freestanding paragraph. Is this prevailing party in any such action in which the purchaser claims a right of voidability based on the contractual provisions.
I don't know that the specific performance claim would have triggered a
But
separate
what would it have been
obligation.
premised? What would have been premised on?
The
What right to what right? The specific performance based on what right?
specific performance based upon the right of first refusal contained in the declaration of condominium.
Which is, so that's not, is that an action which the purchaser claims a right of voidability based on a contractual provision as required in 718.503?
I don't know. I haven't looked specifically at that
I
section.
mean, correct me if I'm wrong, and I will, you know, the argument, I don't think the argument was made in the initial brief that had there been, even if there had been fees properly pled, that there wouldn't have been entitlement under 718.303 fee shifting, right? You didn't make that argument, did you?
No, Your Honor, because the threshold is they never pled it. So what's the point of arguing something that they never made it over the threshold to? So I didn't address that. No. In other words, I'm not sure I'm understanding your question, but I want to make sure I am. Are you asking whether if they had pled entitlement in their pleading to conform with Stockman v. Downs, whether or not they would have been entitled to fees for the dismissal of that count prior to judgment on count one? Is that the question you're asking?
Well, you had the little prior to dismissal, but that's obviously you're saying that informs the answer, right? So yeah, sure. Well, you can answer it that way.
Okay. And the simple answer is no, I didn't research that issue because to me, Stockman v. Downs ended the debate.
So every time, and I mean, I read Suarez, so I'm answering this question with fully apprised of what the second DCA said there. But you're willing, I'm presuming, to say that every time there even if someone has entitlement to fees, statutory or contractually, if they file a motion for fees having not pled them, and every time, and there's a 57-105 served, and then the safe harbor period run, that they're entitled to sanctions, the opposing party is entitled to sanctions?
I believe under Suarez, yes.
Okay.
So I don't know if I even have any time left.
You do.
Pardon?
You do. You're at 12 minutes and 30 seconds.
Thank you.
I got a quick question because I just
Yes,
want
sir.
to roll out something. The transcript of the December 2022 hearing is not in the record. We asked for it. Is that dispositive of this issue? I was assuming that it may have dealt with whether you had waived it or tried it by consent and not necessarily a statutory issue for fees. It's just. Go ahead.
What happened is I got the order. I immediately contacted the court reporter. The court reporter actually filed it by, I believe your order was entered last Monday. The
Right.
court reporter filed it by last Wednesday, and then the circuit court clerk indicated that they had taken care of it. My assistant even followed up, and then they said they'd already transmitted it to the second district. And then I asked my assistant to try to reach your clerk's office to confirm that something didn't get lost in transmission. And
Sure, we are going to read it. I assure you.
Yes,
We
sir.
will read it. I guess I'm asking you now, do you feel as if it's dispositive of any of your arguments?
It's not dispositive. It merely supports my argument. For instance, if you were to read the top of page 10 of that transcript, you'll see where Mr. Moore invited error at the trial court level. Again, I cite to the Bokenberger case, right? where without any basis for it, for the first time, he says, and I'm quoting at top of page 10, line
But,
1.
but we don't have it in the record, so
Okay.
we can't really
I'll just
argue
say-
right now. I'm just curious because it's kind of rare for a trial court to handwrite things in. I mean, when I was a lawyer, they used to do it in Sarasota and it was really annoying, but Judge Duraka decided to handwrite something in there that had something very important, the entitlement to fees. And I'm just, we'll figure that out. Go ahead, sir.
All right, and I would simply just point out, if you were to look at this entire file, and I have numerous cases in front of Judge Jurotka. Judge Jurotka is well known to handwrite a lot of orders. I mean, to literally handwrite the orders, not just interlineate submitted orders from counsel. So just so the court's aware of that, it does happen quite frequently. I guess my time is largely up.
Well, you're right at 15, so.
All right, I'll reserve for rebuttal then. Thank you.
All right, sir. Thank you, Mr. Moore.
Yes, Your Honor, if it please the court.
Yes, sir.
Some of the factual issues that I think that needs to be filled in the blanks here is that count 1 was the improper notice not provided by the Lowrys in this case. But what plaintiff was asking for was not only the voiding of the deed, but then the integral part for their whole complaint was forcing Lowry to give notice to the association, which was a condition precedent to their count 2 claim, which was sell us the unit for $14,000. The court, in ruling on that, on count 1, put in their order that the court was troubled by the behavior of plaintiff in this case and did not grant them that forced notice provision. Therefore, the condition precedent to count 2 goes away. So plaintiff had no choice but to dismiss count 2. Dismiss count 2 way past the statute of limitations. And there is a basis that if there's a voluntary dismissal of a count of complaint, that the defendant is entitled to attorney's fees under this case. We go around, we get to their December 1st, 2022 hearing, in which I argued that point, which precipitated Judge Jurotka handwriting in the paragraph 4, opening the door, permitting defendant in this case to file a motion for attorney's fees in this case. We looked at it. I filed the motion for attorney's fees, albeit there was no motion for rehearing on the part of the plaintiff, no appeal of that final order regarding paragraph 4. So we go forward, we file our motion, we get the January 13th letter of 23 from Mr. Haas to me, along with the motion 5715 motion. The letter is basically saying, look, I've got so many vast years of experience, your client just needs to agree to $130,000 judgment, and we should stipulate to it, my client denied that offer. But looking at the 5715 motion, I was, I don't know the word, shocked, surprised that Dan Greco, the previous attorney that I took over for, who's got 40 plus years worth of experience, did not have your standard wherefore clause on his answer. That sends me into, all right, some of a panic mode, looking at how is there a way to get from point A to point B? Because I filed motions in this case requesting attorney's fees, not a pleading, albeit. Defendant Petrika, he filed pleadings requesting attorney's fees. So those fees were in play during this case. And to say that the case was just on count 1, the case was all about count 2. Plaintiff, defendant Lowry, within 6 to 8 months of this case being filed, admitted she did not give proper notice to the association. Count 1 was a foregone conclusion. It was done and over with in 6 to 8 months. The 8-year fight was over count 2, which was going to force Lowry to give notice, and then plaintiff would pick up this property for $14,000, of which Mr. Petrika had already put $50,000, $60,000 of work into. So the case was all about count 2. Count 1, from Lowry's standpoint, had been admitted to within 6 to 8 months of this case. the integral part of count one was that forced notice to the association, which would trigger the right of first refusal on plaintiff, which puts us into count two. When that went away, count two goes away, and plaintiff properly, because no condition present was there in order to exercise the right of first refusal, dismisses the count, which gives rise to Lowry's, position that they're entitled to fees. Looking at that, I look at Rule 1.190 on conforming the pleadings to the evidence. Did vast research, let other attorneys confer with them, could not find anything for or against that would say that we would be successful. I am under a duty to vigorously defend any case on behalf of my client. I put in the motion for attorney's fees, preserve that right. And then after seeing the motion by Mr. Haas, I see that there is a way from point A to point B. It's novel. There's no case law saying you can or you can't do it. So going forward, I'm just saying, look, it is reasonable that if I am able to prevail on conforming the pleadings to the evidence, that we would then be entitled to, at least at a minimum, a hearing on attorney's fees entitlement in this case, which I believe she would be entitled to that. And that's the basis of what we went forward on. It was not a frivolous pull out of the ether, devoid of any merit, cause of action or, motion filed on my behalf. There was a way that if we get this motion to conform to pleadings to the evidence, that we then get our attorney's fees.
Let me ask you
With
this
that-
about that theory.
Yes.
And you could remember that theory. So a lot of the pleading requirement, some of the pleading requirement case law talks about the fact that, or it maybe makes a distinction, and I'm not going to profess comprehensive knowledge of these cases, but in my review of some of the cases, the concept arises as to whether the party that should have pled was aware at the time of pleading to the potential for fee entitlement. So your theory is premised on the idea that even though, your party should have known, there's a fee shifting provision. This is based on a chapter 718 provision that has a fee shifting provision attached to it. I might win on count two. That's why you plead it. So your theory of conforming the pleadings to the evidence is that, well, even if you fail to plead that, well, if they dismiss, that's something new, they dismiss voluntarily, then therefore that's some sort of procedural fact to which I can conform the pleadings. But how's that any different than just winning on count two, which hopefully is always your objective and underlies the rationale for pleading it in the first place? There might be entitlement. I got to plead it.
The case, Your Honor, if we were successful on count two, we would still be back in the position of conforming the pleadings to the evidence. We would still pursue the same.
But I mean, again,
strategy.
how is that different than any other case in which the pleading requirement had been omitted? What evidence are you conforming it to?
That's the issue that the opposing counsel brought up, was that evidence of attorney's fees. It's a pleading. There's no evidence. I've never seen where people put on evidence, as to entitlement of attorney's fees prior to post-judgment. It's a post-judgment, argument.
Okay, so then I'll repeat the question because it's a question. What evidence did you intend to conform your pleadings to?
Well, I conform the pleadings to the evidence of Trika put in attorney's fees. I brought up attorney's fees and motions, and that the plaintiff was on notice that attorney's fees were in play, and never once brought it up that wasn't an issue.
Okay, so the evidence is like,
so
in other words, essentially like my words, not yours, procedural facts.
Your Honor.
Procedural facts is that the plaintiff is that they were on notice. How are they on notice?
Well, for Trika's answer, I have several motions which I requested attorney's fees. Whenever at the final hearing.
But so if that were the case, In other words, then that would sort of be, that would be something, you're creating an exception that eats the rule, right? So in other words, you could say, well, I didn't plead it, but then I included it in subsequent motions, and therefore now I can conform the my pleading to the evidence that he's on notice subsequent to my pleading because I put it in motion. So wouldn't that eat the rule? Every time you could say, hey, you know what? I didn't plead it, but now I'm going to conform the pleading to the evidence, which is I later moved for them in my summary judgment motion.
So that's the way you put it, Your Honor. Yes, that would be the case. And in looking at the rule, there was nothing before or against that, and that's why we preceded it. And it put me in a position of, you know, with the 21-day clicking away, I can't withdraw that motion because then I waive attorney's fees. In order, you know, so I can't withdraw the motion for attorney's fees to comply with 57105 and then pursue the motion with the pleadings, conform the pleadings to the evidence, because then I've waived the motion for attorney's fees. So I was put into a procedural corner that I wish to pursue the one in order to bring this back into play. I would have waived it, and then it's over. By withdrawing that motion, I waived the attorney's fee issue for my client. So the performing
But
the pleadings evidence
but
comes to me.
wasn't it, isn't the argument that it was waived already? It's
Correct.
waived by
Yeah, I mean
failure to plead?
that's counsel's argument that it was not brought up and waived under Stockman. Yes.
So again, how do we differentiate this from if we wanted to affirm and write an opinion, how would we distinguish this from Suarez again?
Well, Your Honor, we're today's purposes, we're looking at an abuse of discretion. So it's whether the court, if there's anything paid on the record of the paid on the record that shows the court used its discretion, then the court would take action based on that. There's nothing of the record that shows the court abused its discretion. So I don't know how we get to Suarez, because the standard of review is abuse of discretion, whether the lower court arbitrarily, unreasonably took action. No reasonable person can reach that viewpoint. You know, the case law after case law says abuse of discretion, and that, you know, for it to be frivolous or an action that the party doesn't need to have conclusive evidence to prove their pleading at the time of filing it. I was just in the position of if I withdraw it, then I enter into the realm of waiver, that I've waived the attorney's fees, and I can't get back there. So pursuing the motion for conform the pleading to the evidence was an approach to keep the attorney's fees in play. And if we're successful there, we would be entitled to attorney's fees, because the second cause of action, count two, is 718-303, but it was to enforce the contract. Under the contract, there's attorney's fees provisions. So it's a two-pronged position that Lowry would be entitled to attorney's fees, not only under 718, but under the contract which they wish to seek civic performance of. So that's the purpose of where the Lowry would be entitled to fees under this case.
But going back to that's the merits of fee entitlement. But going back to the issue on which this seems to turn, which is that it was under 57105, your attorney's fees claim was unsupported by law and the facts. That's what Mr. Haas is going to argue, at all times relevant, right? And the question is isn't that the same thing that happened in Suarez? And I'm wondering whether your only argument for distinguishing Suarez is that you filed a motion to conform the pleadings to the evidence. And then doesn't that motion have to have some merit in order for us to distinguish Suarez?
Your Honor, and I think it does have merit, and it has merit to the extent that there's no ruling one way or another as to my position in the filing of that motion for the pleadings. I researched it extensively.
So
And I
are you arguing then, sorry, uh, are you arguing, for a good faith extension of existing law or something like that? In other words, the exception in 5705. In other words, you're arguing this is a novel theory, and because there's no case law prohibiting it, therefore.
Yes, that's it. That's it. It's that there's no case law one way or another that you have to, for the benefit of your client, especially in a case that's at the time 10 years old, and parties have hundreds of thousands of dollars, put into this case, that you have to vigorously pursue this for the benefit of your client. It wasn't just capricious out of nowhere, trying to just delay and take up the court's time. I'm not that kind of an attorney. I make sure that I'm measured in my actions. And I felt that at that point in time, because this appeal is upon me, I felt at that time that I wouldn't, if I withdrew that motion for fees, pursue the performance motion, I waive the fees and I can't get back to fees. So I'm in that corner. I
But
pursue the
isn't
court.
that the horns and dilemma that a party is always on when faced with the 57105 motion? Hey, I was really trying to swing for the fences here, and now I'm on isn't that the point of the rule, to put you in the horns of a dilemma? If I swing and miss, I get fees assessed against me.
Yeah, that's the purpose of
Mixed
5705.
metaphors.
That's not in, I'm not in doubt today. I'm not calling it in doubt today.
So let me ask you this: Suarez is a case that I don't think you even disagree that it's a little bit difficult for your case. It's good for opposing counsel's case. What cases could you point to, or did you point to in your briefs that in which a court said, this was non-meritorious ultimately, but we think that it wasn't totally devoid of merit under the standard. What would be a case or two that would support your position here?
The case law that I have that I presented to the court and I have for today is all regarding abuse of discretion, whether the court made a mistake. Was the court devoid of any facts, and any reasonable person would reach that decision? And I think the record is clear that there is a basis on which the court reached that decision, and that the court didn't abuse its discretion. The court did not abuse its discretion in this case.
But going back to the standard of review, if I look at that candidate in paragraph 4, final judgment, and 12-15-22, it specifically makes reference to the plaintiff similarly, because in paragraph 3, the entitlement is based on
statute 718 and 57. So this paragraph seems to be very related to paragraph 3 in terms of the defendant's entitlement appears to be by statute. Doesn't mention any waivers, so it appears that our review might be de novo.
Well, there's nothing in the lower court's ruling that said there was any ruling based on a statute or a contract.
Maybe I wasn't clear.
Right.
Paragraph 3 says the plaintiff's entitlement is based on 718 and 57 Florida statutes. Paragraph 4 says your client may be entitled to attorney's fees and taxable costs against plaintiff similarly. What is similar about this other than the two statutes?
The word means what it means. I mean, similarly, I don't know if it really, it's vague at best. I mean, as to what the judge is referring to, he's referring back to the 718. But even under 718, entitled to fees on count 2, and even under, but the count 2 is the enforcement of a contract, and that contract It's
I
filed with the court.
understand that, but the initial
Is
answer
attorney's
was May
fees.
of 2016, and we go almost 7 years until you file a motion for fees. And then seek to amend your answer for an entitlement to fees, and we had 7 years. Where you never pled an entitlement to fees whatsoever. And then all of a sudden, in December of 2022, wait 6+ years after your answer that didn't plead entitlement, the judge says you have entitlement based on statute.
So recession of the facts. I was not into the case until 2018. So the 7 years, first 4 years, I was not involved as to the case.
I understand that, but you're an attorney and you kind of reviewed the prior attorneys, and you also made reference to the prior attorney and how experienced he is, and that you were kind of flummoxed why he didn't do what he's supposed to do, but nothing was done for 6 or 7 years. You've got 2 minutes.
In conclusion, I mean, I think what we have here is that the plaintiff, it's an abuse of discretion. There's nothing under the court ruling that it was based upon a statute or a contract. Case law is clear that it's a heavy burden on the plaintiff in this case, and abuse of discretion, and that the record there has to show patently that the judge abused his discretion in this case, and that we would ask the court to affirm the lower court's ruling.
Thank you. Okay, Mr. Haas, 5 minutes.
Thank you, Your Honor. Judge Atkinson, I believe you made an excellent point about a meritless motion to conform pleadings to the evidence does not excuse a meritless motion for fees. That's the issue before you. With respect to the statements that counsel's made, the law is very clear that a request for attorney's fees in a motion, not a motion to dismiss where there's no answer, doesn't come within the Ajax exception, which I cited in my brief, which is, one of the exceptions to Stockman v. Downs. The fact that another party pled an entitlement to fees on count 1, they weren't even a party to count 2. There's no case that I'm aware of that says that there is attorney's fees awarded by osmosis, where as long as one party in the case seeks fees, then that means everybody's entitled to recover fees.
I was going to ask you about that. True, as far as I know as well, that wouldn't obviate the pleading requirement for the other party. But what about the good faith argument that, well, I shouldn't have said good faith. I only presume good faith, and I don't forget I said good faith. I mean, there's no issue of good faith here. It was all made, strenuously argued below. But was the party on notice? The party opposing fees on notice. Is that an argument? Does that take it out of the realm of devoid of merit, of frivolousness to say, well, this is unique in relation to Suarez because, look, someone had already pled fees under the same basis?
No, sir. Here's why. A few reasons. And it's all very clear in the record. Number one, Mr. Petricca was only sued on count 1 to invalidate. He wasn't a party to count 2 for specific performance, because once the deed to him was invalidated, he would be nobody to the case. In other words, at that point, it would only be the Lowrys that specific performance would be against them. So that's first point. Second point is, if you go and read the actual answers and affirmative defenses, not only did the Lowrys fail to assert a claim for attorney's fees, but they specifically disavowed that there was any basis for attorney's fees to be awarded. So for instance, and I'm looking at the second amended, the answer and affirmative defenses to the second amended complaint, which was the last operative pleading, filed on March 25th, 2016. And if you look at the 8th affirmative defense, they specifically say, quote, plaintiff is not entitled to the recovery of any attorney's fees. Section 718-303 is limited to actions for damages or injunctive relief. Additionally, section 718-303 would not apply to defendant Patrick Petricka prior to the time he became an owner or if the subject sale is rescinded. Oh, I'm sorry, this was the answer of Mr. Petricka, but there is a similar answer. Give
So
me
you're
one
saying that, but you're saying that in Mr. Petricka's answer, he both pled fees under 718 and said the plaintiff was not entitled to fees under 718.
Right, right. But what I'm also saying is, and I'm trying to
That
find.
kind of undermines the point you were making, I think, but.
Well, no, there was also, right, but there was also an answer in defenses by the Lowrys filed on December 28th, 2015. And they
Well, you
did
can-
not, again, they don't assert any basis for attorney's fees at all in their answer.
We
So-
know that, right?
Okay, and then I want to correct something that counsel said, that this was an 8-year fight over count 2. Again, all you have to do is look at the record and see that that's false. I tried to get summary judgment on count 1 based upon requests for admissions. I can't explain the trial judge's refusal to grant summary judgment after I got them to admit my request for admissions, but he did. And the record is very clear that the only trial that happened in January of 2020 was on count 1, which was to invalidate the deed. So it is not a true statement to say that we were litigating count 2 for 8 years. That's just false, just flat out false. So again, the only question for this court is, as a distinction from Suarez, is whether a meritless, and again, if you read the transcript of the hearing, Mr. Moore admitted there was nothing there, right? There was no evidence to amend the.
Right.
To
But
conform
I mean,
to.
you harp on that, but I mean, he has to admit that because then also he kind of judo flips that to what he believes to be his advantage by saying, well, what facts could there be? You know, this is about fees. But my point is, you know, I was making the point, which I think was a, you know, approximation of the point made by counsel below. If we're conforming to procedural facts, right? There's no evidence.
But I don't even know that there's any procedural facts to conform these pleadings to, and I'm not aware of any concept in the law of a procedural fact as opposed to an evidentiary fact.
I'm not saying that I know of that either. I'm just
Okay.
posing this as a theory, and then saying, you know, is it plausible to say, well, the procedural facts have changed. You know, there's been a voluntary dismissal, which gives rise to entitlement. That wasn't something we were anticipating.
The count was dismissed after it had been pending for several years. It was dismissed on June 7th, 2022. This lawsuit was filed in August of 2014. They'd had nearly 8 years to decide if they wanted to file a pleading saying we're entitled to fees if you don't prevail on this claim.
You have 20 seconds, John.
I'll yield my 20 seconds. Thank you, Your Honor.
All right. Thank you. Thank you both.
Thank you.
Have a nice
Your Honor.
day.
Thank you.
You too.
All right, we're on to our last case on the docket.